Hello, dear students. Welcome to What, Why, How, the daily initiative by IAS Baba, where we take up a current affair or an editorial and we declutter it in 10 minutes or less. The topic that I have chosen for today is something that is now doing the rounds due to two different cases altogether. So, you would have seen this in the very notorious case that was there in Kolkata, the Kolkata doctor rape and murder case, which was there. Very recently, the court convicts the chief accused, which is Sanjay Roy, to life imprisonment. This is the first case that is there. And at the same day, in fact, on the very same day itself, there was another verdict given by the Kerala High Court. And the Kerala High Court had the verdict was given in the case called as the Sharon Raj murder case, where the court awarded death sentence to the chief accused, which is a lady, which is a woman called Grishma, and she's just 24 years old. So this is another case that is doing the rounds. Now, the reason why I've taken up these two cases is not to discuss about these cases, but on one hand, one case, the convict or the chief accused was awarded life imprisonment, and the other case, the chief accused was given the death sentence. Okay. Now, when it comes to the death sentence and your life imprisonment, in both of these cases, the respective judges used a term called as, in one situation, the case did not qualify as a rarest of the rare case. And in the other situation, the judge said, yes, this comes under the rarest of the rare cases. So this prompts us to understand why is it that, see, in one of the cases, it was a very brutal rape and murder. And in the other one, it was a very pre-planned murder of an individual. In both of these cases, the judges differed in their opinion about what constitutes rarest of the rare case. Now, this is our topic for today. So, let's have a discussion on what exactly is this rarest of rare. What cases do qualify as rarest of the rare cases? See, in India, to award the death sentence to a person, you cannot award it on any other criteria, but what they check is if the case that is involved belongs to the category of rarest of the rare. Now, this doctrine came into place in the Bachchan Singh versus State of Punjab case. In this case, the Supreme Court had given certain criteria, certain measures that could be checked if it falls under the rarest of the rare case. Even after this case, several other judgments, we will just see some of the judgments in this discussion. Several other judgments actually improved upon this criteria, and finally, now this is what the court follows. The reason why there was such a doctrine is, see, some cases not only affect the individual and the family, but it shakes the society's collective conscience to such an extent that any kind of leniency to that criminal would be very inappropriate. This was the prime idea when it came to rarest of the rare. Now, to put it into actual terms, legal terms which are there, in the first, after the Bachchan Singh case, there were several other cases called as the Machi Singh, the Dattatreya's case, etc. In all of these cases, what has now evolved is, if something has to be declared as rarest of the rare, the crime must be of exceptional brutality. It should be so depraved or of a heinous nature. Any factors such as extreme brutality, premeditation means how much planning went into the crime, and the manner in which crime was committed are considered. If you remember, this is how the Nirbhaya case was, or the whoever was accused in the Nirbhaya case was given death sentence because of this criteria. The crime should have an impact that goes beyond the immediate victim and affects the society at large. If you noticed, when the Kolkata rape case did happen, it prompted people to come out on streets, to conduct candle marches, to again cry for the fact that the women's safety is not yet there. Even after several years after the Nirbhaya case, also women's safety is much at a risk. So it did affect the society's conscience at large. But again, the it is finally the court's judgment that matters over there. So just keep this in mind. It should affect the society's conscience at large. Then the court goes on to talk about two major factors, some called as aggravating factors and some called as mitigating factors. Aggravating factors means any kind of factors that can make the situation or the crime worse or the criminal worse. The presence of aggravating factors are, for example, if the victim involved is belonging to a vulnerable category like a child or an elderly, etc. Then another aggravating factor is betrayal of trust. Another one is repeated offenses. If a person involved has undergone or has done repeated offenses, even there, what you can have, these are all aggravating factors. Mitigating factors, on the other hand, are the ones that could actually justify a lesser sentence. As in, like, if at all, if the person involved is extremely young, not a juvenile, but extremely young, to award death sentence might be a little bit on the extreme side of a punishment. So, conversely, the mitigating factors that could justify a lesser sentence, such as offender's background, age, mental state, potential for reform, may strengthen the case for imposing, or in either case, if the person is someone who has no potential for reform, then it makes sense to award death sentence according to the Indian courts. Finally, the judiciary must consider whether any punishment other than death would be adequate and proportionate given that the gravity of the offense and its impact on the society. So that also has to be checked if it could be possible to give any other punishment. Now, based on all of these things, what happens is several cases in our country are brought under the rarest of the rare, and certain accused are given death penalty and certain accused are not given death penalty. Now, at this point, what needs to be discussed is, see, at the end of the day, rarest of the rare is a very subjective criterion. Now, as I just pointed out, on the very same day, two cases which both had affected the society's collective conscience of their respective societies, the verdict came in two different manners. That means there is a subjective application of the rarest of the rare doctrine, and this can be quite problematic. Another problem is inadequate sentence hearings. That means when someone is actually given a death penalty, they should have heard the case in such a thorough manner, have explored every single aspect of it, and without any doubt should be able to convince that yes, this person or whoever is the accused is the final accused in this case. There is no change in it. So you can see the Supreme Court in the Dattatreya versus State of Maharashtra case commuted a death sentence to life imprisonment. That means they reduced the sentence to a life imprisonment because the convict was denied a real, effective, and meaningful hearing during sentencing. So this can be a mitigating factor that can maybe reduce the intensity of the punishment. Then limited focus on reform. Ideally, the scope of reform, someone who is a repeated offender who has committed several crimes in the past might have very less chances of reform because he would have already suffered jail time for it but still did not have reform. So you have to clearly explore if there is a chance for a reform. And again, in the Santosh Bariyar versus State of Maharashtra case, the Supreme Court emphasized that the prosecution must provide clear evidence proving that the impossibility of reform. They have to state different factors that show that this person cannot reform and you have to award death sentence, or this person, if given a smaller sentence, will again maybe commit a crime of the same nature. So in India, we do have rarest of the rare doctrine, but the rarest of the rare doctrine is actually not implemented in a very equal or a very what you say objective manner. And this has led to a lot of human rights activists coming forward and saying that maybe this should not be the criteria for awarding someone death sentence. So I hope in the context of this particular cases and for the cases in the future, you are clear on what rarest of the rare doctrine is and what are the issues of rarest of the rare doctrine in our country. I hope to meet you again. Until then, take care and happy learning.